All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. We'll begin today with the public reprimand of Judge Stephanie Moon. Good morning. Judge Moon, as you know, to resolve separate cases filed against you by the Judicial Qualifications Commission, you have admitted that you violated the canons of the Code of Judicial Conduct through 3 distinct instances of misconduct. Earlier this year, our court approved the Commission's recommendation that your discipline for those violations consist of a fine, a 10-day suspension without pay, and this public reprimand. Your misconduct was as follows. First, in open court from the bench, you asked an attorney who had just appeared before you why he hadn't returned your call, asking him to serve on your re-election campaign committee. That interaction was obviously inappropriate and inherently coercive to the attorney. Second, in a different matter, you engaged in ex parte communications with a witness, a therapist, to discuss the mental condition of a party in the case. Finally, in violation of clear provisions of the Code of Judicial Conduct, you made financial contributions to various political organizations and candidates. On top of all that, the Judicial Qualifications Commission had already cautioned you in 2019 for improper campaign activities. Judge Moon, your behavior in these instances is unacceptable. In 2 of the instances, you caused harm to persons who appeared before you. You have discredited yourself, and your thoughtless actions have risked undermining public confidence in the judiciary as a whole. Judge Moon, we hope never to see you again under circumstances like this. Our duty to the public and to the judicial branch will not allow us to tolerate any further misconduct by you. Your reprimand is concluded and you may leave. Thank you. We will now take up the case of Perlmutter versus Federal Insurance Company, number 2024-0058.
Mr. Chief Justice, and may it please the court, Jesse Panuccio for petitioners Ike and Laura Perlmutter, who are with us in the court today. The clearest way to see how the 4th District departed from the statutory text of the general punitive damages statute is to compare it to the punitive damages statute for nursing homes, 400.0237. Initially, in 2001, the nursing home statute copied Section 1, subsection 1 of the general punitive damages statute verbatim. But in 2014, the legislature amended it to say that the court must hold a hearing at the pleading stage to consider evidence submitted, quote, submitted by the parties, end quote, and whether the claimant at trial will be able to demonstrate by clear and convincing evidence that recovery of such damages is warranted. That difference in language has meaning, both the change to the pleading burden and to the requirement to consider evidence by both parties. If the prior language in the nursing home statute, which copied the general punitive damages statute, already had these elements in it, there would have been no reason for the legislature to change it. And indeed, until the 4th District's decision, no DCA and nor this court had interpreted the general punitive damages statute in this way. It is a complete outlier. And since the 4th DCA's en banc decision, no other DCA has joined the 4th District in its statutory interpretation of the general punitive damages statute.
I know it's pretty new, but have you had a chance to read the Medfast case from the 5th and Judge Saud's concurrence, where he went through a pretty thoughtful analysis of this? And it seems like he's, to some extent, he basically, I mean, just to summarize, at one point he says Section 768.72's requirement that a plaintiff prove entitlement to punitive damages by clear and convincing evidence is important and informs the trial court's evaluation of the reasonable basis for an award of such damages. I'm just curious.
Yeah, well, and that would be somewhat the same reasoning as the majority judges in the 4th, but for a host of reasons that I'll outline, I think that is wrong, and I'll take the court through that. So let me turn first to the pleading standard. Obviously, we have multiple issues in our brief. The two questions of statutory interpretation are the pleading standard and also what is the court considering? The evidence just put forward by the claimant, or is there a counter showing that's allowed? So first of all, I think the thing to note about what the 4th District's done here and what that concurrence would say is that it's essentially moving the pleading stage to a directed verdict stage. In fact, if you look at the 4th District's test or the general test in Florida for a directed verdict, it is almost verbatim what the 4th District has now said needs to occur simply to get a claim into the case of punitive damages. And there's no basis for that in the text. There's no context for it if you look at the larger statute. And again, precedent is nearly uniform, except maybe that concurrence across the state. And when I say the precedent is uniform, we're going back to the original enactment of the statute in 1986. No court interpreted it this way, and that includes, at the time, the standard would have been preponderance. Remember, 1999 was about raising it to clear and convincing, the ultimate burden of proof. But no court from 86 to 99 said that to make the reasonable showing of a reasonable basis, you must meet the preponderance standard.
I'm sorry to interrupt you, but don't you think you make the point that on the standard of review issue that there's been a lot of sort of not necessarily thought out adoption of the de novo standard, and that part of the problem here is that because of the cert mechanism, there really wasn't an opportunity for until recently, and maybe we're regretting having changed that rule, but now there's a ton of these appeals, and it seems like the standard of review thing maybe is something that needs to be looked at. It seems like this issue of how do you understand the reasonableness inquiry, so I completely understand what you're saying, but I'm wondering how much weight we really should give to these not necessarily kind of it seems like this issue is really being illuminated and kind of tested now, arguably for the first time in this context.
So, Mr. Chief Justice, let me say two things in response to that. One, as we've stated in our brief, I do think it's important in this case for the court to address everything, and that would be what is the proper interpretation of the statutory text, both what is the pleading burden, and two, whose evidentiary presentation should the trial courts consider, and then the standard of review, because the interlocutory appeal is new and we have the district courts sort of unthinkingly, without reasoning, I should say, adopting the standard of review that existed before. And then lastly, we think it would be important in this case, especially if any portion of the 4th District is upheld in terms of the framework, to apply the new framework to the facts of this case, to give a demonstration to districts around the state about how this should work. Let me address the standard of review, because I think you were asking about
Well,
that.
why don't you stay on the statute?
Stay on the
actually,
statute? Okay.
yeah.
So going back to the pleading standard piece, looking at the text, there is a pleading burden. My friends say in their response brief that there's no burden. The only burden in the statute is found in subsection 2, and it's clear and convincing, but that's not accurate. The pleading burden is, quote, reasonable basis for recovery. And that reasonableness is a well-known standard in the law. It appears in criminal law quite often. It appears in civil law quite often. And we have, in fact, we identified in our brief statutes that use that very term, reasonable basis. And it is articulable. Like all burdens, there is sometimes, some effort to define it, and that's why we have jury instructions and so forth. But, for example, the First District said in ACCA versus MVP Health, they were interpreting reasonable basis in a different, unrelated statute, but they were able to come up with a fairly ready definition. They said reasonable basis is somewhere above frivolous and below correct.
And it would be so easy for the legislature in this statute, as in the statute you started off talking about, to say a clear and convincing basis, correct?
Exactly. And in fact, it's really important to focus in on the fact that there is this interplay over the years, starting roughly in the 1980s and then all the way through 2014 between the general punitive damages statute and the specific statute for nursing homes. And if you look at the amendments that were made and even the legislative reports, it's sort of going back and forth where there are some carve-outs for the nursing home statute, and then the nursing home statute repeats verbatim subsection 1. The exact same language, and then the amendment comes in 2014, and they move, this is what's so striking about it, they move exactly to what the 4th District says the general punitive damage statute should say now, but the legislature clearly saw a difference there, or they wouldn't have amended it in 2014. So yes, it would be quite easy for the legislature to make this change, and if it had wanted to, it has over 40 years of judicial precedent now not doing what the 4th District has done, and it could have made that change. So I think that's exactly right.
From
Justice
a precedent perspective, do you accept the gatekeeping function characterization of the trial court's role in this context, and then how does that operate in a reasonableness standard?
So, Justice Sasso, that goes back to this court's decision in Globe, where the court characterized it as a substantive right and also a gatekeeping function. Regardless of the characterization as a substantive right, I suppose all procedure is a substantive right for one party or another, whether a claim can come in or not. But I think it's appropriate to say it's a gatekeeping rule. The question is, what is the gate? And, the normal standard for pleading is frivolousness. You just have to have a good faith basis to make the allegation. I think what the legislature did in 1986, and we still have that original language in subsection 1, is to say, it's not just going to be allegations. You have to show something behind it. Come forward. We called it in our brief a show your work requirement. Come forward with a reasonable showing of evidence that would allow me, the trial judge, as a gatekeeper, to say, okay, you've got something here. It's, again, somewhere above frivolous and below correct at a trial level. And as long as you can make that reasonable showing, then punitive damages, a claim only, can proceed. Now, remember,
meaning it survives a motion. Procedurally, walk us through that. When you say it may proceed how far? Like it all the way until the jury? Is that? Oh
no, I think just Kirill, I think standard litigation practice still is in place here. So after there's a amended complaint, as with any amended complaint, you can move for summary judgment. You can move for partial summary judgment.
So I guess that's my question. How does it interact with the summary judgment standard? What do I have to do to survive summary judgment if all I've done is allege something that is more than frivolous but less than correct? I then have to show what degree of absence of dispute of material fact.
Well, I think at summary judgment, let me step back. If you look at how this statute operates, it still contemplates two things at the pleading stage. Three things, really. One, it contemplates that there will probably have been some discovery before you move for punitive damages, although that doesn't have to happen. It also allows for discovery after. And third, it allows for a proffer of evidence, and that's important and I think somewhat ignored in the Fourth District's opinion. What is a proffer of evidence? It can come in many different ways. It could be just a attorney standing at the podium and saying, this is what we will show in future depositions.
Right, this is the soul of the case. You know,
right.
I offer to you, this is what you're going to get.
I will take depositions, or I will have witnesses on the stand, and they will testify to the following. That would be a proffer. Now, a proffer could be more formal. You could actually proffer a witness, and nothing in the statute prohibits that you could say, look, I want to do a formal proffer, and here's what the witness would say.
But it doesn't require it either.
Does not require it. But all that is to say, Justice Kirill asked, what would happen next? And I think what would happen next is you would have a complaint. It would now be a claim in the complaint, and then you would have whatever discovery you're going to have. You would come to the end of the discovery period, and then the defendant can file their motion for summary judgment and have it adjudicated under the normal summary judgment standard. And if you get beyond that... And
I'm sorry to interrupt you, but I mean, it is interesting that it seems like there's precedent that would support the idea that, at least at the summary judgment stage, and when the court is trying to decide if there's a factual dispute that requires resolution by the jury, it seems like there is support for the idea that the clear and convincing aspect would factor into the court's assessment at that point.
Well, I think that's just standard summary judgment practice. I think once a court's at summary judgment, it often looks to the ultimate burden of proof. That is, and the summary judgment test is malleable for that. So whatever the burden of proof is in that case will factor into the judge's decision at that stage. Right. But at that stage, it's much more appropriate because you have the fully developed record at that point.
And that's obviously, I think that's a strong argument. I mean, I think what makes this challenging is that this is, having this gatekeeping role is sort of a unique function, and there's a sense it doesn't seem like it would be wise or fair to turn this into the same thing as the summary judgment thing. But at the same time, it's not crazy to say that if what the judge is being asked to do is to see if there's a reasonable basis for recovery of punitive damages, not to factor in ultimately sort of what's going to be on the table for that. I mean, I think that's the hardest. I think that's what makes this difficult, is that it's an awkward fit with sort of the procedural posture of the case at that point.
Well, let me see if I can address that. I think what we have here is a gatekeeping function that is one step up from normal pleading. So normally, if you want to amend a complaint or just file it, as long as the allegations are in good faith, as long as you're not in 57-105 territory, then you can do that, and it's assumed every attorney will file it that way, will adhere to that rule. I think what the legislature was saying here is we're going to need a little more before you subject a party to the financial discovery, but it's still just the discovery phase, and what they're saying is, clearly in the statute, make a reasonable showing. Show us there's something there. And I think, Chief Justice Muniz, if the Fourth District's opinion is correct, what we're going to have at the pleading stage, merely to get it in, is a full-blown mini-trial. And if you look at how they applied their framework to this case, the evidence in this case is fairly overwhelming. I mean,
it's actually, I'm not sure. I mean, and let me ask you about that, because I think part of what's going on with this case is that it's not, I think, and I don't think that we should try to kind of add like yet another wrinkle to the certified question or anything like that. But I think one other sort of latent uncertainty that I think is going to end up having to be litigated more now that there's going to be a lot more attention on this stuff with these appeals is that the relationship between the statutory test for the intentional misconduct and then some of this kind of common law language. So if you look at the Fourth TCA opinion, they say that what the target here is seeing, did the defendant specifically intend to engage in intentional or grossly negligent misconduct, which sounds like you're just sort of like then alluding to the statute. And then it says that was outrageous and reprehensible enough to merit punishment. And so that's where, it seems like, there's been a lot of back and forth here, and each side has their kind of characterization of what's in the record and everything. But, I mean, I think one of the challenges for trial courts in this area is it's one thing to kind of see was there a knowledge of wrongfulness, and I guess there's some ambiguity about that, and then there's the issue of did you know that damage or injury was likely to come, but then it's when it's, is there a reasonable basis to say that the conduct was quote-unquote outrageous and reprehensible enough? That whether you're talking about clear and convincing or just some lesser reasonableness thing, that to me doesn't seem like that's, and this, I know that you make your argument about the abuse of discretion thing, but it seems like that's hardly like something that everybody's going to kind of universally agree on.
Maybe not, though, again, that definition has been in the statute since 1999, and although we didn't have interlocutory review of the merits of that, even after final judgment, courts have been reviewing that for years, and we do have definitions in cases. So, for example, wrongfulness, the second DCA has said it's conduct that is contrary to conscious morality or law. You know, some of this is a judgment call, and some of it's going to be a judgment call for the jury. I mean, it's that kind of standard.
Well, but it is, but I mean, and this gets back to the challenge that the legislature has sort of foisted on the courts is to, you know, it seems like it's kind of either, you know, some people kind of emphasize kind of how extraordinary punitive damages are and what a sort of case transforming moment it is. And then I think it's also reasonable to say, look, it's early in the case. Yes, the novelty here is that we have to show our work as opposed to just having everything assumed to be true that we allege. So I think that, I mean, I think that just from sort of at that level, I think that there's appeal to kind of both ways of looking at it. Well,
what I would say is that if this case cannot pass a framework, either the one we're proposing or the Fourth District's, I believe it would be hard to find a case that would, and here's why. What Mr. Perenboom said, and then what his counsel told the insurance company, this is at record page 4371. The goal here was, quote, to terrorize his adversaries.
Okay, and that's just really, I mean, I understand why you're saying that, but that's deliberately writing to his supervisor about getting a different lawyer involved in the case in the context of talking about trying to figure out what's going on. I mean, there is nothing where Perenboom is saying, I want to, quote unquote, terrorize this couple. I mean, I understand your perspective on things, and I understand the other side's perspective on things, but that's, I mean, I think that I think that the reason why even judges who agreed with you on or I guess Judge May, who agrees with you on the test, still thought that it didn't even meet the reasonableness thing is because the evidence of having this kind of, you know, obviously unsavory approach to getting the DNA is very strong. The idea, though, that there was some sort of plot to kind of manufacture fake evidence for the specific purpose then of defaming people and hurting stock prices and affecting people's careers, I mean, I'm not saying that you can't argue that, but that's hardly, I think people applying a reasonableness test to that part of it, you could easily see fair-minded people sort of going either way on that.
Well, let me say two things. One, even accepting that, and I'll push back against it in a moment, but even accepting that, that's precisely why I think you get through the gate, because a reasonable jury, as the evidence develops past a proffer and into putting these people on the stand and asking them and saying, what did you mean when you said you were going to terrorize your adversaries? And they have to make a credibility determination. But let me push back on the basis. One, that email, bringing the other lawyers involved. What were the other lawyers hired to do? They were hired to pursue the investigation into the hate mail campaign and get the DNA evidence. And they were trying to use this Katie case as a cover for that investigation. And what do we know about that? What did Perenboom say? He said,
I'm sorry to interrupt you. Obviously, the people that are more sympathetic to the other way of looking at the case they're acknowledging sort of the unsavoriness of the DNA collection part, but they're also saying that on the other side, this person was being accused of being a murderer and a pedophile, and that there's tons of evidence in the record suggesting that he was genuinely trying to find out who was doing this. Obviously, he had his ideas as to, you know, what his suspicions were going in, but this wasn't, I mean, I don't think that there's any aspect of this that suggests that he wasn't genuinely trying to find out what was going on.
Well, even if that was going on at the same time with respect to Mr. Perlmutter, here's what he said. This is at record page 3899 to 3900. He spoke to his lawyer specifically. The lawyer said, why are you invoking Disney? Why do you care about this? And he says, because if we can connect Mr. Perlmutter to this hate mail campaign, it will have a material, this is a quote.
He didn't say if we can connect. He said if this person had done X, Y, and Z.
Right, but that's the context of it. It's to use it to get him fired from Disney.
You're very aggressively, and I'm not criticizing you, but you're very, and I think that I wish the fourth DCA had kind of explained itself more so that we could kind of all evaluate their thinking. But I think that when they're talking about stacking inferences and whatever, it would have been helpful for them to say, like, what are the inferences that are being stacked? But I suspect that what they're getting at is that the idea that this was some kind of manufactured, it's almost like the tail wagging the dog. Like the whole point of this was to harass the Perlmutters. I'm not saying, you know, what the kind of metaphysically sort of true answer to it is, but the evidence that's in the record is far from clear on that.
In April, March or April of 2013, just 2 months after the fake deposition, okay, Mr. Perenboom goes ahead and directly accuses on a phone call Mr. Smith, the person he had fired right around the time that the hate mail begins. He says, you did it, on a phone call. That's what Mr. Smith testified.
He said something about it, right?
And then, well, that's what he testifies, but Mr. Smith testifies that's what happened on the phone call, and that's the type of thing, who's more believable, that should go to a jury. But for several years beyond that, even after Smith is arrested, he continues.
Hold on, but he got arrested in 2017, and most of the interview with the Globe and Mail was in 2016.
Well, but his lawyer, but he had very good reason even in 2013 to suspect Mr. Smith and in fact accused him. But even after the Globe article, and even after he leaked it to the press, which itself is problematic, he was still trying to test the Perlmutter's DNA and push this even after the arrest. So when you put all of that together, there is at least enough to get beyond a reasonable showing. And I did want to address when you said the fourth DCA accused us of stacking inference upon inference. What's very striking about the test that they say they're applying and then the test they apply, they say every inference must be drawn in favor of the movement of the claimant. And then when they go through the analysis in this case, they draw nearly every inference against us. And so I think that shows how unworkable the test is. They say they're not weighing evidence, but then they weigh.
Let me just ask you this, though. If they're, and this is where I think that the uncertainty in the test comes in, if they're, let's say that their assessment of the record is that that Perenboom genuinely wanted to know who was doing the hate mail, that the means that they used to get the DNA were, let's say that they were illegal, let's say that they were in violation of the court order, et cetera, but that they were working with law enforcement and that genuinely this was motivated by a desire to find out what was going on. Where is this outrageousness and reprehensible enough to merit punishment come in? Do you think that there's a way to read the fourth DCA that they're basically saying that in the context of what was motivating what was going on, that this was not outrageous and reprehensible enough to merit punishment?
I don't think the record supports that at all at this stage. Multiple trial judges have had this case and came to the opposite conclusion in various different orders, not only the order to allow punitive damages, but also the various sanctions orders and the orders on the crime fraud exception. So the judges who have been closest to this, multiple of them, have not come to that conclusion. But even if, to take the hypothetical, that you came to the conclusion that yes, there was a genuine desire to find out who was doing this, but they decided to do it in an illegal way, I don't think sanctioning vigilantism is how this case should proceed. At the end of the day, there is testimony that Duberly said, the reason we did this is I just didn't want to go through, quote, some lengthy court process. And there's email after email where he says, even when he says, don't bring your hired guns, he says, this is, you know, at the outer edge of what we could possibly do in this case, and I don't want any red flags for the judge who may stop us. That's an officer of the court.
Can I ask you one thing, because of your time? On the issue of the scope of the record, I understand completely the idea of not wanting to turn this into a quote-unquote mini trial, but do you read this so narrowly that, for example, if the claimant only puts in sort of portions of a deposition transcript that the other side can't even say, you know, here's the rest of it? Because I know just from my own experience of going through this case, like if you don't read, if you only read 2 lines, you have no idea what's going on. You know what I'm saying? So how would we, you know, if we adopted your perspective that it has to be only the information put in the record by the claimant, I mean, how would that work in practice?
Yeah, let me say 2 things about that. One, I think it's a textual matter. Whatever the practicalities are, the statute is very clear. It's by the claimant, and we know this not only because of the way the properly applied nearest reasonable referent canon works, but also, again, just compare the nursing home statute, where they moved from by the claimant to by the parties.
Which, by the way, I mean, in general, as a theoretical matter, do we usually look at language from 2014 to try to decide what the public meaning of language written in 1999 was?
Well, 2 things about that. One, I think the court can look at statutory history and how the statutes have evolved, but 2...
You're using the 2014 thing to basically kind of illuminate supposedly how something in 1999 would have been understood.
Well, and then was understood by courts for many years in that way, and then the legislature said we have to make a change. I do think that has meaning, but even if you take...
let's get back just to
the issue. The question I believe you were asking was, how would this work? Okay, so it works the same way a complaint does. So again, normally you have a complaint and there are allegations, and what is the defendant allowed to do? The defendant is allowed to say, even if these allegations are true, you fail as a matter of law. There is one other thing a defendant is allowed to do. If there is a document incorporated into the complaint, you know, there is a rule of completeness for that or a rule of incorporation. So if a complaint extensively quotes from a contract, typically the defendant is allowed to bring the whole contract forward at the motion to dismiss stage, and that would probably be appropriate here, but it can't be, if it's not something that's fairly incorporated into the showing of the claimant, I would think it operates very similar to motion to dismiss practice, because again, we're at the pleading stage. This is only a claim, and that's all subsection 1 just says, to permit a claim, not to win, not to prevail, not to win on summary judgment, just to get the claim into the case. So I think it'd be very similar.
You can have a minute to finish up and then 3 minutes on rebuttal.
I'll just hold for rebuttal. Thank you very much.
Thanks.
May it please the court, Jordan Cohen for appellee respondent Harold Perenboom. I've reserved 5 minutes principally to answer any factual questions that the court may have. It sounds like the court is very familiar with the developed record. There are a few things that I will note that were stated by my friend. They acknowledge that they have to show their work. And the fourth DCA sitting en banc, when it actually looked at the work that they had shown, found that there was not evidence of outrageous and reprehensible conduct. Now, I know we're here on a certified question as to the standard to be employed, but I think if we divorce the facts, then we run the risk of allowing punitive damages. And again, my friend said this is just about discovery, but this is about a substantive right, a gatekeeping role, and it's about the right of privacy under the Florida Constitution. And if we simply accept a proffer, I heard today that it can be an oral proffer, which it can't be under 1.190. If there's going to be a proffer, it needs to be provided in writing 20 days before the hearing. And I would respectfully suggest, while proffer is both a verb and a noun, there really was no proffer in this case. What was presented to the trial court in this case was a record. It was a record based on discovery. It was a record that was based largely on deposition testimony.
But what do you think the trial court's obligation is in that case? Is it not to, I mean, if we're looking at intentional misconduct, is there evidence of wrongfulness, or is there evidence of actual knowledge? Is there evidence that there was knowledge that there was a high probability of injury? Or is it to compare the evidence and provide an assessment of weight?
No, it's the former. There is no weighing of the evidence. The Fourth DCA was clear on that. But the test for intentional misconduct, and these are only intentional torts that have been asserted here. That is the only aspect of 76872 that applies. This is not about grossly negligent conduct. Is they have to establish actual knowledge of the wrongfulness of the conduct, which the Fourth DCA sitting on bonk said they can't do, looking at the record, and that there was a high probability that injury would result, but that the course of conduct was still pursued. How does the court evaluate that? It evaluates that by looking at the record. It doesn't just look at part of a deposition testimony that's been cited in a situation where a witness may actually recant that testimony on cross-examination. There were two examples that were...
I'm sorry to interrupt you. Why do you think that the reader of the Fourth DCA opinion can understand why they thought that there was not sufficient or reasonable evidence of the wrongfulness or knowledge of the wrongfulness of the conduct?
I think it's laid out in the background section found at pages 28 and 29 of the opinion, and it talks about, as Your Honor said in some of the questioning, it talks about the fact that this was an individual who's a victim of a crime. These facts are not in dispute. Immediately reports the crime to law enforcement, is having real-time discussions with law enforcement about the fact that he is going to, because the town of Palm Beach lacks the financial resources, is going to be engaging a private lab to perform comparative tests between the hate mail and something else. Now, I understand that multiple judges, I agree, take issue with the manner in which the reference samples for Mr. and Mrs. Perlmutter were collected. And that's what we're going to have a trial about next month. But there's no evidence that there was the requisite state of mind. Punitive damages are about punishment. That there was the requisite state of mind on the part of Mr. Perenboom that he was engaging in wrongful conduct by conducting that testing that he was discussing in real time with law enforcement. And two of the facts that were talked about by my friend here, that there was a plot to manipulate the testing, also a reference to David Smith's testimony. Those sorts of allegations, that's why it's so important to look at the record. And I don't want to talk about aspects of the record that have continued to be developed in the trial court since the record was closed for purposes of this appeal. But respectfully, those are arguments that I'm surprised to be hearing in light of how the case has developed. There is no evidence that Mr. Perenboom or the lawyer who was defending him in the Katie action, again, whether or not Mr. Dubberly was acting appropriate, that's going to be tried, raises issues regarding litigation privilege, etc. But there is no evidence that there was anything afoot other than trying to understand, and the Perlmutters were not the only individuals whose information was reference samples were collected and tested, the only ones in this particular fashion, but they were not the only ones. There is zero evidence that there was anything afoot other than trying to understand who was actually behind this and to make it stop. I've used my 5 minutes. Unless the court has any further questions, I'll yield to Mr. Falls.
Thank you.
Thank you.
May it please the court. My name is Travis Foles. I represent William Dubberly, who was the attorney that was assigned to represent Harold Perenboom in the underlying defamation and tortious interference case, which we've referred to as the KD lawsuit in shorthand. And I want to begin just by reiterating this is a review proceeding based on a certified question in conflict, and it has far-reaching implications across the state and for all civil litigants. The answer to this question should not be dictated by the facts of any one case. But I do want to very briefly, before turning to some of the legal arguments, address some factual misstatements that were made about my client, Mr. Dubberly. My friend mentioned that William Dubberly admitted that he did not want to go through some court process, some lengthy court process, and that the deposition was a cover for the DNA collection. If you look at the actual record, and the record citations that are cited in our briefing, you'll see that Mr. Dubberly denied any knowledge that there was some rule or some law that required going through a court process or filing a motion or seeking consent. And respectfully, my colleagues here haven't cited to any statute or rule that required that.
But I mean, it would be a fair inference from just the way that this was conducted that they I mean, if they thought that it was okay what was going on, I think wouldn't a reasonable person have been upfront about what was, hey, I'm going to take this bottle that you drank from or this paper. I mean, I do think I think everybody agrees that you can draw reasonable inferences from the evidence in the record, right? And
Your Honor,
people who thought that what they were doing was okay, I don't think would have gone about the DNA collection in that way.
Well, Mr. Dubberly, what he said about what they did, and again, I think you need to account for the context in which this was done, right? Which is what the 4th District did, staying true to the record. The 4th District understood and recognized that this was done in an effort to try and determine who was behind a heinous hate mail campaign.
That gets to the ends, but not the means. I mean, to the extent that there was wrongfulness on the collection end, it was the means. It wasn't. I mean, obviously, if they'd been up front and said, hey, we want to test DNA, whatever, then that whoever's responsible and has authority can do that, can try to do that. But
well, what Mr. Dubberly has said is that he likened this to surveillance, where you don't need to ask consent. You can post up a private investigator outside of a deposition and videotape someone as they leave.
Okay, can you focus on your legal stuff?
I can, yes, Your Honor. So there's two primary points before I cede my time to Mr. Lang, who I know is planning to address the finer points of respondents' legal arguments. But there's two primary points I think compel approval of the 4th District's en banc opinion and rejection of petitioners' challenges. And the first is the petitioners' arguments in their 100 pages of briefing and here today are all based on a fundamental misunderstanding of the 4th District's true holding. They seem to believe and have represented that the 4th District has required application of the clear and convincing standard at the pleading stage. That's not true. That's not what the 4th District has said. The 4th District has said that you need to keep in mind and view the evidence and proffer through the prism of the ultimate substantive burdens that the jury is going to have to apply when they hear this case at trial.
How's that different? What do you mean?
There's a distinction there because there's no weighing evidence. That's another thing the 4th District has said. There's no weighing evidence. There's no judging witness credibility. You're not deciding whether or not the clear and convincing standard has been satisfied. I'm sorry.
They say that, but isn't clear and convincing evidence definitionally a weighing exercise? I mean, how we define clear and convincing evidence is evidence of a character that's believable. It requires a credibility determination. And from the quantitative standpoint, a weight that can convince somebody to a degree. So how do you apply a clear and convincing standard in any context at the pleading stage without necessarily going through that kind of weighing exercise?
Well, from a practical application standpoint, we have some precedent. We have a framework for how that's going to be applied, and that's the standard articulated in Anderson versus Liberty Lobby by the U.S. Supreme Court. That court has said that when you're evaluating a claim that has to be proven ultimately by clear and convincing evidence, you view the evidence through the prism of the substantive evidentiary burdens, because it makes no sense to decide what a reasonable jury could do if one were impaneled today unless you account for what must ultimately be proven to recover. And that takes us right back to the language of 768.7.2. Subsection 1 says that there needs to be a reasonable basis for recovery of such damages, which, of course, refers to punitive damages. Subsection 2 informs that reasonable basis language, which is not a recognized evidentiary standard and is not defined in the statute. So subsection 2.
So why would we map? So when we talk about viewing the statute in context, why would we not also view it? It's dropped in the statute's dropped in the context of how litigation in Florida operates, which pleading standards. I'm trying to think of another pleading stage. I mean, the legislature all the time, there might be verified pleadings in some cases, heightened kind of pleading requirements. But can you think of any other pleading stage where this weighing factor kind of comes in? Well,
again, Your Honor, there is no weighing of evidence under 768.7.2. The 4th District was very clear about that. And admittedly, 768.7.2 and amending to plead punitive damages is unique. There is a unique process that's been crafted. So use your language.
Any other pleading standard that requires the court to, at a motion to dismiss stage, for example, to view the evidence through a specific evidentiary burden?
Well, I think it's done on summary judgment. That's what the court said in Anderson.
Summary judgment, again, being different from the pleading stage.
That's true, Your Honor, but I think, again, there's been, the way the precedent has developed around 768.7.2 is that there's a legislatively crafted gatekeeping function that's specific and unique to punitive damages. it is, in a sense, one of a kind, right? And so the only way that a trial court can effectuate that gatekeeping function and can effectuate this court's directives that litigants are not supposed to be subjected to financial work discovery and punitive damage claims unless and until there's a reasonable evidentiary basis for such claims is to keep in mind and view the evidence and proffer through the lens of what the jury must ultimately prove. And at the end of the day, this is a question of statutory interpretation. And I think the only way you can discern what is meant by a reasonable basis for recovery is to keep in mind the ultimate burden that the claimant has to prove to recover. And that is the clear and convincing evidence standard, that's the intentional misconduct standard, and if applicable, the gross negligence standard. And with that, I'll see the remaining.
Can I ask you a quick question before you sit down?
Yes, Your Honor.
So I understand that it was kind of, it's maybe sort of baked into the certified question, but this issue of what the trial court is supposed to look at, the record, whether it's only stuff that the plaintiff puts in or anyone puts in. In this case, so two things. One, am I right that there's not really a conflict on that issue? As far as I can tell, there isn't sort of disagreement among the DCAs on that. And the second question is, in this particular case, from what I can tell, I didn't see that there was any, basically this case was sort of argued about and decided in the context of what the claimant had put into the record. Like, I didn't see that there were any fights being adjudicated in front of the trial court as to, hey, we concede that if you just look at what the plaintiff puts in, you would think this, but look at this other stuff that we want to put in. I mean, am I right that in this particular case, there wasn't really a dispute about that aspect of it?
Well, I guess let me address your second question first. I believe there was additional record evidence that was pointed out in defense of the motion for leave to amend. As my colleague pointed out, there was no real proffer by the plaintiffs in this case. It was all record evidence.
Right. But by them. I'm just saying, was there, in this case, was there something that the other side wanted to bring in that people were fighting about whether the court should even be allowed to look at that?
I don't believe there was a dispute about trying to exclude some additional evidence, on the motion for leave to amend. Okay. To your initial question, the cases that the 4th District certified conflict with from the 2nd and 5th DCA do not explicitly state that you cannot consider record evidence that's pointed out or the
conflict is on whether you factor in the clear and convincing issue.
I think so, but there is in fairness and in all honesty, I mean the Despain and Cook opinions do talk about application of like a motion to dismiss standard. Implicit in that is that you would take the allegations and evidence as true.
But that's an issue of whether you accept it as true versus.
True, but implicit in that is that you wouldn't consider, you'd accept something as true and not consider counter evidence, that paints a more complete evidentiary picture.
Okay, thank you very much.
Thank you, Your Honor. Thank you.
May it please the court, Joseph Lang from Carlton Fields for Federal Insurance Company. So how does Federal fit into all of this? And why is Mr. Lang going to talk about the certified questions? And the punitive damages claim against Federal is based on vicarious liability. And it's Mr. Dubberly who is the, quote, employee or agent that would be the basis of any vicarious liability for punitive damages. And so the first basis for allowing ruling in favor of Federal that the 4th District announced was, we have said that Mr. Dubberly is not subject to punitive damages, and therefore if the agent/employee is not subject to punitive damages, Federal would not be.
Okay, so can I put a pin in that for 1 second?
Yes.
So if the court were to conclude that the 4th DCA applied the wrong standard and to send it back and say, hey, here's the correct standard, apply it, does that mean that I think you may have some more arguments, but at least from that perspective, you kind of rise or fall with Dubberly? Like, if that had to be redone as to Dubberly, would you be swept in with that?
Yes, Your Honor, only on that first basis, though.
Okay.
Because the 4th District then went on, and I don't want to spend all of my time talking about something my colleague hasn't even mentioned, but the 4th District went on and gave multiple independent bases under 768.723. That's the vicarious liability section, gave multiple bases for why federal should not be subject to punitive damages that are completely removed from the certified question. So even if you did what you said, which is quash the 4th District and send it back, the ruling as to federal and punitive damages should stand under that separate subsection 3 reasoning, that there is no corporate policymaker who's been identified. I'd like to talk about that in a moment. I'd like to talk a little bit about the certified question because we do have a vested interest in that.
You can have a few extra minutes.
Okay. On the certified question, I think we've pretty well circumscribed what the issues are. I think the conversation has developed to the point that there is a little bit of concern of how do you, on the ground, practically apply what the 4th District is saying? Because the 4th District really is not creating a revolutionary change in the law. I think the 4th District has done a very cautious, conservative, modest reconciliation of subsections 1 and 2 and identified the meaning of the whole text. But they are not saying that we are going to create many trials or weigh the evidence at the preliminary determination stage, at the motion to amend stage. We're not going to judge credibility. We're not going to make evidentiary determinations.
But how do you respond to and it was, Justice Sasso asked about it, and I think Judge Warner talked about this, and maybe Gross. I mean, how do you respond to the idea, though, that by asking is the evidence clear and convincing, and because of the way Florida defines the clear and convincing issue with the looking at the nature of the evidence itself and then also how persuasive it is, I mean, how is it not inherently requiring the judges to kind of weigh the evidence or assess its credibility and that sort of thing, which seems very, I understand the analogy to the summary judgment thing, but it seems very kind of alien to the posture of the case at that point.
I understand the concern about the fact that this is at a pleading stage, but I think some credence needs to be given to the fact that this court has observed that it is supposed to be a gatekeeping function. If you don't put any weight, in my brief, for instance, I explained, I gave an illustration based on my colleague's explanation of what he sees the standard as being is just above frivolous but below correct. You'll remember he says that in his initial brief. And so I say in my answer brief, just how low that standard really seems if you're going to have a gatekeeping function. And in their reply brief, they don't even disagree with my articulation of how low the standard could be under their articulation. And that really doesn't give any weight at all to gatekeeping. I mean, there's no reason for
Not
this
necessarily,
procedure.
though, because I think in this case you see that there are thoughtful judges who, even applying, or at least the one judge, even applying the reasonableness test, she thought that your side of this case should prevail. And I do think that a lot of this comes down to, I don't think that the evidence in the record compels the conclusion that any reasonable juror would think that there was this plot to defame someone. Obviously, there's kind of an admitted obsession with trying to figure out what was going on, but I don't know that the case at the end of the day necessarily stands or falls on which test applies.
I think, though, that depending on where you are bringing your motion, that if we don't at least require a reference to the clear and convincing evidence lens or the prism of what the jury would eventually have to decide, that these can devolve into almost nothingness hearings because the bar is so low.
Let me ask you this. Under your understanding of that point and what the 4th District has done, how does that differ from what has been done in the other statute that was changed by the legislature, the medical malpractice statute, where the clear and convincing is up at the beginning? So are those going to be different things, or are they going to be essentially equivalent?
I think they would be essentially equivalent. I just don't think the fact that Chapter 400, 15 years later, was amended reflects what 768.72 plainly means. I don't think that's a doctrine of interpretation that we backward
look. We do look at what the legislature's done, and there's this thing is, they know how to say it, and if they've said it in a particular context and they've not said it in another context, a context that's like cheek by jowl. I mean, it's the same context.
But I think
they say it one way in one place, and they don't say it the other way. But regardless of the timing on it, inferences can be drawn. But maybe because of the timing, your point is that's got nothing to do with it.
I think the timing makes a big difference. I think if you go and look at when this court has said, look, the legislature knows how to do this. They've done it. It's because they'd already done it, and then the statute you're looking at in that particular case, it wasn't done again, and you point and you say the legislature knows how to do this. You don't have the situation where the legislature did this in 1999, 15 years later they write it a slightly different way, and you use that 15 years later to say, well, now the legislature...
No, I do think, though, but that's one of the weird paradoxes of this stuff, is that to the extent that part of when you're looking at related statutes, later adopted statutes can have the effect of sort of implicitly changing or modifying or clarifying the meaning. And it does seem like one of the goals of our interpretive enterprise is to have a rationality across the law, and it does seem like it would be weird to read two things that are so differently worded to mean the same thing. I mean, I understand what you're getting at, but it's not, I mean, the argument that they're making about that is kind of within the sort of four corners of kind of normal interpretive practice.
I do think, though, that it's strange to change the meaning of what I think is a plain statute. So
if you want to go plain statutes, and you mentioned the 4th DCA reconciling, why is there any need from just this statute in isolation? Why is there any need to reconcile? We have what is clearly in one a pleading standard. Then we have when a defendant may be held liable only if the trier of fact based on clear and convincing evidence. It's clearly talking about a different part of the proceeding. Why is there a need at any point? What holes are there in subsection 1 that need reconciling?
Because the question you would ask is a reasonable basis of what? And so
why isn't it not what you need to sustain punitive damages, which is then defined in 2A and B?
Right, in 2.
From a legal standpoint. And that's how we look at pleadings across the board, isn't it? I mean, if you submit a verified pleading where you have to allege ultimate facts and that sort of thing, we're looking at it through the lens of the legal standard and not a burden of proof standard, right? In all aspects of litigation.
In subsection 2, it sets out the element, and I am well over. I assume I have leave to be well over.
He went over. You can go over. It's with our help.
Subsection 2 is adopted, even under his theory, to set out the elements of intentional misconduct or gross negligence. It also ought to circumscribe what a reasonable basis is, because that's what the jury would have to do at the end. Let's take this example, which is not that far removed from clear and convincing evidence. What if the standard in subsection 2 and then again in the following section were beyond a reasonable doubt? And I think this is kind of what the concurrence you mentioned at the very outset is getting at. What if it was beyond a reasonable doubt? Would we really say that barely getting past frivolousness at a motion to amend stage really...
and again, I mean, that's replicated in the law well in criminal pleadings. But can I ask you on the showing, just limiting it to the claimant, why why, when we're looking at this through the lens of a pleading standard, which I think we can all at least agree it's a pleading standard, are we not defining that reference to claimant is not defining who can proffer? And so it's a showing, the showing must be by the claimant in any pleading. It's by the person who's seeking the damages. And so why should we not view that as limiting who can proffer? In other words, the defendant is not going to proffer. In this case, it's going to be the claimant that proffers. And then evidence in the record is also evidence that needs to be submitted by the claimant. Why is that not a correct way to view that provision?
Well, there are practical answers and then the grammatical answer. I don't need to.
I'm just talking about in terms of interpretation.
From the practical answer, what we see.
From an interpretive standpoint.
Well, interpretive, I would say that the nearest referent, the interpretive canon the 4th District used, I think the better reading of it is that it's the entirety of the evidence or the proffer by the claimant. I agree with that interpretive method, but the reason it matters, or the reason that makes sense as a matter of interpretation, is to avoid these rule of completeness problems that have been referenced already. The Plaque amicus brief sets some of those out, as well as to what we see in real life practice when you are not able to point to any evidence beyond the so-called proffer at these motion to amend hearings. You have things that turn out just not to be true being presented by snippet, and you don't have the rule of completeness. But this is a nice opportunity for me to end, I think, with a question that didn't get fully answered from you, Justice Sasso, because the other way that this is important to look at the totality of the evidence is in the identification of ambiguity. And this is where you don't have to weigh the evidence at the preliminary determination stage in order to evaluate clear and convincing evidence, because all the inferences go in favor of the movement, Inconsistent evidence can satisfy the clear and convincing evidence standard down the road for a jury. Conflicting evidence, we know. There's
just, to me, like if we're talking about resolving, looking for context to help give meaning to the language that's chosen by the legislature, if it's at the pleading stage, we're not talking about summary judgment. There's stages of pleading or stages of litigation where that exchange of evidence is expected in litigation, but at the pleading stage, why would we read it beyond how we understand pleadings work in Florida?
Because this is a unique mechanism. I mean, I understand exactly what you're saying if this was just a pleading mechanism, but this was set up to have some degree of bite by the legislature to create a gatekeeping function. If it's going to be treated as just a very early pleading bump in the road, it's not going to have any bite, and you have to question, why did the legislature set this up at all, and why is it a substantive right to be free from punitive damages until some showing is made if it's just this little bump in the road that, you know.
Just to finish your point on the ambiguity thing, could you give us a concrete sense of what, because it's such a hard concept.
I agree.
Like, what is the evidence in the record? And let's just stick to their record. What is it that you're saying is quote unquote ambiguous?
I would say the state of mind, the specific intent. I thought you were going to ask a slightly different question, which was put some concrete nature to this idea of ambiguous as opposed to conflicting.
So I guess my thing on the ambiguous thing as applied here, it's that it's not, to me, it's not so much a matter, I don't know if I would label it an ambiguity as to what is the reasonable inference that one can draw from what we're looking at. And so if one person is writing to a third party saying he wants to hire a lawyer who terrorizes his adversaries, kind of in context implying like other lawyers that you're litigating with, you know, is it a reasonable inference to draw from that this entire plot was to terrorize this other couple? I would say no. You know, you could look into something else, and what's the reason? So is that what you mean when you say ambiguity? I mean, is that just a different way of making that point?
Well, I mean, to be very discreet about ambiguity is, I think that if you have story X by one side that is not an interpretation of the same facts, but basically a different opinion, a different factual basis here and a factual basis why here that are conflicting or inconsistent. I don't think that's ambiguity.
Correct.
I think when you have basically an agreed nucleus of facts that are susceptible to
two reasonable people could look at them to draw.
I think that's where ambiguity arises,
right? But that helps. That seems like that has to cut in their favor, because then it seems like if a reasonable person could read this email and say, "Yes, I'm a reasonable person, and I think this says I'm going to terrorize this couple," and then the other one reads it and they're a reasonable person and they say, "This is just talking about hiring a lawyer who's a jerk who's going to make the other lawyers' lives miserable." If that's reasonable, if two reasonable people could reach those conclusions, then that has to help them. So why is that wrong?
That's why it's so important to view this through the lens of clear and convincing evidence, because if it is ambiguous, you can't get over that evidentiary hurdle at the end. That's where ambiguous evidence cannot satisfy clear and convincing. And so when you look ahead, could a jury take what you just described as, inferences on both sides? Could a jury take that nucleus and decide by clear and convincing evidence that the plaintiff had prevailed?
Of course, ironically, on appeal, we would just be saying, is there competent substantial evidence for whatever the jury did? So so the whole thing is bizarre. But anyway, go ahead. 30
I think you see where I'm going, which is if you
Yeah.
look at it through the lens of what the jury has to actually find at the end, the jury could not take that nucleus of facts and say that clear and convincing evidence has been satisfied. And so that's why I think the 4th District focused on the fact that this is not conflicting or inconsistent stories. It's ambiguous, and if it's ambiguous, it can't satisfy the clear and convincing evidence standard.
Okay, thank you very much.
Can I make just
30 seconds, please?
30 seconds. On the, which my colleague didn't reach, but I want to make sure that it's clear. There are independent bases under subsection 3 for federal to have the 4th District's decision approved. And the case law, Augusto is the case I want to make sure you look at footnote 2. We cited it. They did not respond to it in the reply brief. But it says that you do need to have a corporate policymaker in order to impose vicarious liability under subsection A, B, or C. And footnote 2 cites a number of cases that support that view, and they did not respond to any of those. So we would ask you to approve the 4th District's decision, answer the certified question in the affirmative, but for federal in particular, we would ask you to approve on the alternative independent bases, regardless of what you do with the certified question.
Thank you very much.
It's a lot to respond to there, so I'll try to do a lightning round of responses here. But let me start with what you just heard from my friend, that last back and forth with the court. What you just heard is their view that at the pleading stage, the court must engage in essentially a full trial to figure out if the evidence is ambiguous, how someone might weigh it, what kind of credibility to give to any kind of conflict. That is the standard the 4th DCA has adopted, and I don't think it's faithful to the text, certainly not faithful to precedent from other districts.
Can I just, sorry, I want to make sure that in your reply brief, you asked us to reverse and permit petitioners to plead their punitive damages claim. What would your response be to a remand instruction that required the 4th DCA to apply the correct standard?
My response would be any reversal is a good reversal, Your Honor. However, I think what has been made clear in the briefs is that there is enough to pass the hurdle properly defined by the statute. I think that's clear in the record. This case is proceeding. It's going to a trial. I think for efficiency, this has been litigated for years. The most efficient outcome here would be to reverse, articulate the statutory requirements properly, and then also instruct the 4th DCA to essentially affirm what the trial judges found, which is there's enough to at least plead this. And they will have an opportunity to further litigate this claim. If they think they have an opportunity for summary judgment, they can take that opportunity, or they can win at trial. But at this point, I think to go through a whole nother 4th District appeal would be very inefficient and unnecessary based on the record we have. On the nursing home statute, what we did not hear from any of my 3 friends on the other side is any explanation of why. Why does the nursing home statute have the precise regime the 4th District said, in certain terms, needed to be read into the meaningfully different terms of the general punitive damages statute? And to say, well, the nursing home statute came later, so therefore it has no interpretive effect, is both, as I think Justice Kennedy pointed out, wrong as a matter of general interpretive philosophy, but 2, wrong in this particular. There is an interplay between these statutes. If you look at how they were amended over the years, they're always cross-referencing each other, and they're amended sort of back and forth. And I think you can say the reason the legislature amended later is because the general punitive damages statute wasn't doing something that the legislature wanted done in the specific context.
It warms my heart to hear a textualist asking the question why and talking about the reasonableness of the statutory framework.
Well, this is statutory history, not legislative history, and as opinion by Justice Sasso points out, cited in our opening brief, statutory history is a perfectly valid source of textual interpretation. Let me just see if I can hit a few other, if I may, just a few others. On the federal question and remand, if you look at the opinion, for 768.723B, the 4th District had only one ground of rejecting that liability, and that ground was they rise or fall with Dubberly. So if to go back to the question I was asked, if you reverse on Dubberly, you have to reverse on federal, because that was the only ground identified by the 4th District. And if I may, I think I'm over time. Last thing I want to say is there were some questions about the 4th District's opinion not being particularly robust in its discussion of the record, and I think that's precisely why it's important to address the standard of review. If you look at the trial court orders, they are quite robust. They get into the details here. They cite the emails, they cite the testimony, and the 4th District does very little of that. And it seems like the standard of review should be what the standard of review always is for a motion that, or an order that affirms, allows or disallows an amendment, and that has always been abuse of discretion. And in fact, this court, when it adopted the pleading standard for punitive damages in the rule 1.190, it put it in the pleading rule. And those are always, or the amendment rule, those are always reviewed for abuse of discretion. So it would be odd to carve out F and say that sub-provision of the rule alone is going to get a different standard of review.
The challenge, though, is the only reason we amended the rule in the first place was because there was a sense that this was this super important threshold, gateway that people were going through. And if we, and the idea is, look, this is a big deal. The cert review process is insufficient. We need people to have a meaningful opportunity. If we say it's reviewed for abuse of discretion, which, trust me, I'm kind of sympathetic to based on the nature of the question and just the logistical nightmare that this seems to be creating for the DCAs, I'm sympathetic to it, but it seems like whatever we were trying to accomplish by amending the rule would pretty much go out the window.
I don't think that's right, Mr. Chief Justice. I think, first of all,
I mean, if with your standard of reasonableness and abuse of discretion on top of that, I mean, it would pretty much be the end of it.
Well, first of all, there's a gatekeeping function in the statute. This has to happen, unlike normal amendments, which just come in so long as it's not futile. There's already something that's going to happen at the trial court, and I think it would be perfectly appropriate on interlocutory appeal to say, has the judge acted so far outside of the normal bounds of what this statute would allow or typical practice that we need to reverse? But to have this hearing and this review by the trial judge and then do it all over again while the case is still pending seems, one, remarkably inefficient, but two, just not particularly in the interest of the gatekeeping.
Yeah, you can have 30 seconds to finish.
Okay,
up.
so last point I'll make is that Mr. Dubberly's counsel said he denied knowing the rules. So what we have there is we have him in his deposition saying simultaneously, I didn't know there was a rule. I'm not sure that's credible for an officer of the court, but even if it is, he also says, In contrast to that, I didn't want to go through some court process. Figuring out which part of that testimony to believe and how believable it is, that is precisely what a jury does. They listen to a witness and they say, he's saying two inconsistent things. Why might he be doing that, and what kind of credibility do I put on that? And that is precisely why this record, which, Mr. Chief Justice, you said reasonable minds could differ on it. If reasonable minds could differ, it's for a jury. That kind of question is always for the jury.
Thank you very much. We'll be at recess for 10 minutes.
All rise. This honorable court is now in recess. Pardon me, is there a way back to that? Oh, I want to leave it. I understand.
Yeah, I saw that. They don't know how to fill it up. Let's do a half a cup. Stay over there. I don't want to drop nothing on this, mess up that paperwork. So you just keep it over there, okay? Water. Here's the pudding. I need one bottle of water. Need some more here. Yes, sir. pitch over there, and one guy must have took his cup with him. Yeah, that cup there, it's a trash cup. Yeah, just that first one. Ask her if that's hers. Let's let her. It's nasty. Put it right there. You can take, put some ice in that pitcher over there. Y'all got enough water? Okay. And it's ice. Just put water in there. You want to say ice or water? Yeah, just put some ice in there. Put milk. Oh, you fine? Okay. All right. Benny, that's no, you can't do that. Put it back in there. Only in the picture. Okay. You don't want cold? You can pour it in your glass, but you can't have the bottles up there. Just open one, pour it in her glass. Okay. Thank you, Ben. Is that one glass gonna be enough for you? Okay. Take it back to Ernest then. Put your cooler back on the bottom.
All rise. Supreme Court of Florida is now in session. Please be seated.
Welcome back. Our last case today is Jones versus State of Florida, number 2024-1135.
Good morning and may it please the court. My name is Megan Montagno and I, along with my colleagues, represent Henry Jones in this matter. I would like to focus this morning on Claim 1, which is the Brady violation claim, although we stand on the remaining of our pleadings. Mr. Jones is currently under a death sentence in Florida due to the state withholding evidence and taking advantage of an already vulnerable defendant. The state of Florida has an interest.
Can we just zero in on materiality?
Yes.
Okay. So in this case, the expert's report is withheld. The expert report provides additional color on a fact the jury did know, right? You would concede that the jury knows that Ms. Bayo's DNA is on the victim's body.
Correct.
Right? And I think it's also fair to say that when Ms. Bayo takes the stand, jury gets to evaluate the credibility of her statement that she didn't put her DNA on the defendant's body, right?
I agree, although I would just add that, yes, Mr. Jones and the jury knew that her DNA was found on Mr. Perez, the victim's penis, on his body. Right. However, the jury did not know how that DNA got there.
Well, okay, no, but
she lied.
She testified. Mm-hmm. The jury made a judgment about the credibility of her testimony one way or another. And indeed, the jury may have made a materiality determination. That's really my question, mm-hmm. is can we not surmise from the jury's verdict that the jury, if it decided, you just asserted she lied. Mm-hmm. Let's say the jury actually agreed with you. Maybe the jury, isn't it one reading of the jury's verdict to say they may have agreed with you and decided it didn't matter, that perhaps the debate about how her DNA got on the victim might be relevant to whether she had sex with the victim, but didn't change their view about who was responsible for the murder?
I don't know that we can fully state that just because the jury did not hear from a DNA expert from FDLE.
Well, but they didn't hear from a DNA expert on your side either, right? Like there was nothing there's nothing that precluded any expert testimony, right? So I'm not sure that the Brady rule, obviously, one wishes, right, that this wasn't a close case, and we'll have words for the state about
mm-hmm.
it, but I do think that the Brady rule does allow us to credit what the jury ultimately does with the evidence and make a sort of materiality finding itself, don't you think?
Right, and I just think it's important, especially in this context, that things just be broken down, and I hope this is not a too roundabout way to answer your question, but the state did present a very sexually charged crime. Their whole thing was this was sexually motivated, and yet there's no evidence of Mr. Jones ever having sex with Ms. Perez, but there is direct evidence of Ms. Bello having sex with Mr. Perez, and the jury never heard evidence, of that direct evidence. They heard that her DNA was found on his body. Mr. Jones's DNA was not found on his body, and I think that just kind of reshapes and recontextualizes the whole state's argument on this case.
I agree with you that it goes to impeachment about
yes.
Ms. Bayo,
mm-hmm.
and fair enough. But again, let's just think of it like an equation. Let's assume she's fully the variable completely goes to zero. Let's assume she's completely impeached. The jury just finds her completely unbelievable, but maybe irrelevant to the ultimate question. You say the state's theory is that it was a sexually charged crime. Mm-hmm. Okay, fine. I get that the facts are what they are. It's not mutually exclusive. She, had sex with him. The jury made other conclusions as to Mr. Jones. That's the part I'm sort of having difficulty with.
And I don't know that we can really answer that because that information was just never presented. The jury never evaluated the full scope of this case, which is really at issue. As Justice Securial has stated, the main focus on this is materiality. And as the court's aware, non-disclosed evidence is material if there is a reasonable probability that had the evidence been disclosed, the result would have been different. This court can consider directly any adverse effect the prosecutor's failure to respond may have had on the preparation of the defendant's case. Here, the failure to disclose the FDLE opinion regarding the unlikelihood of secondary transfer prejudiced Mr. Jones as he was unable to effectively cross-examine Ms. Bello on her lies about not coming into contact with Mr. Perez. Ms. Bello was consistently asked about if she knew Mr. Perez, how her DNA was found on Mr. Perez. She she continuously denied ever having any contact with him. In order to essentially get around this, the state presented evidence or went with a theory that DNA was on Mr. Perez as a result of secondary transfer from a dirty comforter found within the hotel room. They used this by asking their medical examiner if secondary transfer was possible, which he answered yes. So essentially the state had a DNA issue. There was a DNA, from Ms. Bell on Mr. Perez, and they needed to explain this. The state failed to. They did not call any FDLE witnesses. They did not call any lead detectives who were on the case that spoke to FDLE. Instead, they said it was from the dirty comforter, and the medical examiner said that this was possible because of the medical examiner, who is not a DNA expert, said that was possible. And as I stated, there's no such evidence of Mr. Jones having sex with Mr. Perez. In fact, there's very limited forensic evidence at all tying Mr. Jones to Mr. Perez. The only thing that was found was a hair in the hotel room by the window, not by the bed, which was a mitochondrial match to Mr. Jones. He could not be excluded from contributing that hair, but the state could not say that it was 100% a match.
It's much narrower, though, than that, right? Isn't it down to like 0.26% of the African American population?
Yes, I believe it was, 0.26% of the African American population, 0.17% of Caucasian, and 0.39% of Hispanic population. Okay. Although it is notable that Mr. Jones did share several siblings with his mother who all would have had that mitochondrial DNA.
Is there any evidence that any of his siblings was in the hotel room?
No, but he did have siblings that lived in the area, and there was much evidence that it was not a clean hotel room. And I think at some point Mr. Jones also said that he had been in other hotels in the area previously, and there's also no evidence of when that hair was placed there.
What significance do you place on the deposition of the detective where defense counsel sort of specifically asked about the FDLE report?
I think that deposition is of great significance. She was asked about the FDLE report multiple times. She kind of caged around the answer, and then eventually just said, oh yeah, it's something to the effect of, oh yeah, it's, secondary transfer. That's pretty much how it got there. Or I'm sorry, I think she denied speaking to the FDLE analyst and said, oh, this was my colleague that did this. But yet the note was in her handwriting. She spoke to the FDLE analyst, Ashley Garner, who said, secondary transfer, highly unlikely. It is more a result of direct contact, which again, I just think reconceptualizes the whole state's argument.
Did you challenge sufficiency of the evidence on direct appeal?
I believe so.
Okay.
Yeah. As stated, the state notably didn't call any FDLE analyst at trial. And this information was never disclosed to Mr. Jones. Mr. Jones did wind up representing himself. He never had access to that deposition. He was unaware. He knew about the DNA. He knew about the polygraph, but there was no way for him to ever get this information and ever be able to effectively cross-examine either Ms. Bello, or he did eventually call Detective Rink to the stand, but he would never have the information to effectively direct her and impeach her credibility as well. And I think it's just important. Again, the state's theory was essentially that whoever had sex with this person, whoever had sex with Mr. Perez, was likely the person who committed this murder. And There's just no evidence that Mr. Jones ever had sex with him. There is plenty of evidence that Ms. Bello did, given that her DNA was found on his body near or at the time of his murder. And it is more likely that the person who was in a close, intimate encounter with the victim was the person who committed the crime.
Say we disjoin that. Say we conclude that either the sexual act and the crime aren't necessarily related to each other, or that there was more than one participant in the sexual conduct, right? What relevance to your theory, what relevance to your argument then? I mean, what if we decide that, you know, perhaps she was in the room at or near the time the crime happened, may have been a witness to the crime, or an accessory, or something else, but don't really think, or the jury perhaps, you know, doesn't think that she is a principal to the crime. Do you still have a materiality argument if all we conclude is that perhaps she was present at the scene and intimate with the victim, but not a participant or principal in the crime?
I think so, because I think it goes to impeaching her, because she denied ever having contact with him, and clearly she had.
But isn't what we need to look at under the appropriate standard of materiality here has to do with what the impact on the jury?
Yes.
I mean, it's what the jurors evaluates, whether who did what and who was there for what purpose, but it's just like a pretty significant factor to know that there's a strong reason to believe that DNA got there in one way and one way only.
Right.
That could color their whole view of what is, and because they did not have that presented to them in the way that this suppressed evidence would have presented it to them, correct?
Correct. And I think that, you know, it's hard for me to stand here and say that, you know, I think it would have had an effect on a jury, because it would have just changed the whole outlook of the state's case. And that's something that the jury should have been able to evaluate, and the state just did not disclose it any which way.
Well, isn't it even more significant, though, that this theory that they used to support their own witnesses' testimony, they knew was perhaps not accurate based on their own expert, and they had not disclosed that. It wasn't even that there was just evidence that the jury didn't hear, but in fact this was very particular type of evidence that supported what their own witness was saying, and they used this alternative theory that they knew was most likely incorrect, and suppressed their own experts' version that was incorrect.
That's correct. I think here the state made conscious decisions. They knew they had this evidence. Like I said, they knew they had this DNA problem, and instead of calling the appropriate witnesses, like I said, they did not call anyone from FDLE. They did not call any detective who was on the call with FDLE who heard that information about secondary transfer being unlikely. Instead, they used their medical examiner, who was not a DNA expert, to say that secondary transfer was the more likely situation, and then relied on that in their closing.
To essentially reconcile the testimony of their witness.
Correct, but they still had this complete change in the outlook of their case hanging around that was just never disclosed. And if there's no further questions, I'll reserve the rest of my time. Thank you.
Thank you.
May it please the court. Naomi Nichols on behalf of the state. It seems like, particularly from Justice Curiel's question, it boils down to what the jury believed when they heard from Ms. Bello? Did they find her to be credible or not? And so the
It
only
really
way
has to
that,
do with how this suppressed evidence could have potentially affected what they would believe.
right, the question that didn't
Well,
get
you know,
asked,
we know what they believed, I mean, based on the verdict. But the question is, what would they have believed if the state had not withheld evidence that they were entitled to have?
yes. So she would have been asked, she could have been asked, the question that she didn't get asked was, well, there's an opinion from FDLE that it's highly unlikely that your DNA could have arrived where it did in any other way than direct contact. What do you say to that? She would have had to respond. And so let's assume the jury believed that she didn't have any contact. That's the question that would have changed their mind.
I think that speaks to one potential use of the suppressed evidence, that is for impeachment purposes. What's the state's answer to the other use, the fatal effect it would have had on the overall theory of the case about this being some sort of sex crime? It seems to me deeply inconsistent with the state's arguments, if not possibly with some of the testimony, but deeply inconsistent with on-the-record argument by the state about the theory of the case that the court, that the state, as Justice Grosshans articulated, really could not have sustained in light of the state's own expert report. How do you answer that?
So I'm not sure if I want to clarify, the report was disclosed. The fact that her DNA was found on the victim was disclosed.
Yes, but that's not the experts. That's the expert conversations, the notes, I mean.
Right, the call notes that FDLE keeps when they have any contact with any attorneys or any law enforcement, anybody about a case, they make notes on it. And it's from those notes that we learn of this opinion. There's nothing else in the record from the state attorney's file. There's nothing in there saying that they actually knew. Although that doesn't matter,
well, the
it was withheld.
knew. I mean, because they were talking.
That's right.
It was a conversation between the FDLE people and the police officer, and the state is chargeable with that.
Yes.
Now, I'm not making any accusation about the attorneys, but it is true that the state is chargeable with what the police officer knew. Correct?
Yes, we're not disputing at all that it was withheld, that this piece. But what was withheld, I think, is important to consider. It wasn't the fact that there was DNA, and just the fact that the location of the DNA was found implies sexual contact happened. But they weren't, the thing that the jury didn't have was an FDLE opinion. FDLE analyst was disclosed to defense.
Which was strongly against the way the state argued.
But the state doesn't have a burden also to present witnesses that are
well, no, the state doesn't have a. It's not about the state's burden of presenting witnesses. It's about the state's burden to give the defense evidence such as this that is relevant to the case and that would undermine, at least potentially undermine the state's theory of the case.
Which is why.
And the way they argued it.
Which is why it's withheld. The knowledge is imputed, and so that's where we are. It's where we are. It was a little bit of a messy case. I would like to point out that the murders happened in 2003. He was taken to Tennessee because the Tennessee murders just happened a few days right before. And the Tennessee process finished before he was indicted. He was indicted in Florida in 2011, initially appointed an attorney in the spring of 2012, and then finally the case goes to trial in 2013. And so the deposition where Detective Rink is questioned when he is represented by counsel about the DNA. This was 10 years after her initial investigation. Now, she has a duty to review her records, but that's a long span of time. So it's something to keep in.
Well, but does that really affect the duty here?
No, it doesn't.
I mean, so I think that's interesting and maybe puts it in a little different moral light in terms of the conduct of the police officer and the other folks involved in this, but it doesn't really affect the legal issues.
No, the only question
didn't the call happened, right, though, in 2012?
The call happened, yes. Yeah.
So,
Yeah.
I mean, it wasn't like it had been 10 years since she had the call and made the
That's
notes,
true.
correct?
That is true.
I mean, I think that puts us back in the
Right.
questionable moral grounds.
Yes, it was from the FDLE notes, it was 2 detectives who were on the call. But the only question is materiality, and when looking at materiality, we have to look at everything else. The question is identity in the case. And the defendant represented himself, and he did a pretty good job in his opening and his closing in pointing out the holes in the state's case. The fact that there was DNA evidence on the body that didn't belong to him, his DNA evidence was only in hairs, and he told the jury that that's not enough. He pointed out some deficiencies in his own way and mitochondrial DNA. But the one thing that wasn't mentioned, it was not the only thing that links him to the actual room. There was a shoe print that had individual characteristics, not just the tread and all that, but there were individual characteristics, wear patterns on the shoe that was matched to a pair of shoes that was found in his car. So there's that additional physical evidence that ties him to the scene. His defense was that he wasn't there, he was down in Miami at the time. And he didn't really have any explanation for his shoe other than, well, he has a lot of shoes in the back of his car, is what I recall from his closing argument. In addition to that, I'm sure you're all aware of the other murders that came in to prove identity in the case. The ones that happened right before, the ones that happened a year before, and the non-murder but assault with a very similar pattern that happened on the juvenile, which was brought in by the defendant himself on one of the witnesses that he called. So taking all of that evidence in mind, even if the jury believed Deborah Bello that she did not have any sexual contact with the victim, and the court's finding is, I think she parsed it out well, that even if there was sexual interaction between Deborah Bello and the victim sometime near his death, it's not exculpatory. She called it non-exculpatory, and I think what she probably meant was that it doesn't preclude Henry Jones from then murdering the victim in the same way that he had murdered these other people.
Can we pivot a little bit from exculpatory to perhaps demonstrative of alternative theories of fact? So Dr. Kaiser, an expert put on by the state, am I right?
He was the medical examiner.
Testifies that the murder was, quote, a sadistic act or sadism done for sexual arousal or sexual excitement. So without regard to the sort of Bello's testimony and her impeachment, again, I go back and I'm not sure I heard an answer from you about theory of the case, whether from a Brady materiality perspective, we shouldn't also judge the impact on other witnesses that created a theory of the case, impeachment of whom would have been very different if the notes had been disclosed.
Well, whether or not, if Bello was involved in a sexual act as well with the victim, doesn't preclude Henry Jones from also being involved in the asexual act, or the asphyxiation portion is what Dr. Kaiser, I believe, was referring to, the strangulation on and off and the effects that has on the face. And there's testimony in there about the juvenile who had these same bulging eyes, and the victim down in Fort Lauderdale from a year before who had these same characteristics in the face from this kind of action. And there's nothing tying Deborah Bello to any of these other murders. And the defendant did point out, and the jury got to hear from other witnesses, the fact that the motel, it was a seedy motel, and there was drug activity that was going on there, and there was prostitution that was going on there likely. So these are all things that they knew, and they were able to take into consideration and weigh in coming to the verdict that they ultimately came to. And so would that FDLE opinion have been the deciding factor, that the reasonable doubt?
What about attacks on the quality of the investigation done by the police? Isn't it true that if they had evidence that their if they had had the opinion, they could say there was obviously another person in the room. So why not, other people in the room? Maybe the treads were supplied by somebody else. I mean, a different theory of the defense in this case could have opened itself up on the quality of the work the police did to exclude the possibility that there were other suspects, other witnesses. It seems to me like that's, another potential use that might have been material. Don't you think?
He did point that out. He pointed out the fact that there was DNA from other people found in the room. There was Harry Pope's DNA that was found, I believe, even on the comforter that the victim's body was found particularly wrapped in. And there was a fingerprint from another man who was found on the windowsill. And the jury heard all of that. The defendant pointed that out in opening and closing arguments, that there was other people in the room, other people's DNA, and it wasn't mitochondrial DNA. He pointed out the difference to them, and that fact they weighed this. These are things that they did.
But they weighed it with an understanding that secondary transfer was possible, and I mean, it wasn't. I mean, it was pretty clear that the FDL, well, at least FDLE thought it wasn't. And I mean, that's, to me, that's just sort of making it even more so. I mean, if they found Mr. Pope's hair and then they believed this could happen by secondary transfer too, they're like, oh, it was just a dirty comforter. It doesn't even matter at all. And that's perhaps not what the situation could have been had they had the opportunity to flesh out that FDLE opinion.
The FDLE opinion was that it was highly unlikely, is one of the ways they called it. But it's not the same as impossible. And so the jury would have heard both those things. So instead of just hearing that it was possible, they would have also heard from FDLE that it's highly unlikely. So is that the piece that's going to change?
That's a big difference. That's an enormous difference.
And would the medical examiner have testified that it was possible if that FDLE had, been there from a DNA or from an expert?
Well,
I guess FDLE may not be an expert.
Would the state have asked that question? I'm not sure. Maybe they find another.
Would they have even gone with their theory of secondary transfer if the FDLE thing had been in?
I would hope not. They could have done it another way. They could have done it another way. I think we've pretty much fleshed out this issue. I don't have any more on this point. If there's no other questions about any of the other issues, the state would ask that you affirm the lower court's holding. Thank you.
Thank you.
I would just like to briefly highlight some points made when speaking with my colleague at the bench here. It's important to note the jury never heard this information. The jury could not fully evaluate the evidence or the witness, specifically Ms. Bello, because the state made a conscious choice to not present the information that secondary transfer was highly unlikely. And yes, Mr. Jones pointed out differences, but he did not have the evidence to fully back up his argument. When Mr. Jones called Detective Rink to the stand, the state purposely never asked her the question about transfer, about DNA. They never asked CSI Squad Dyer about transfer DNA. And another important note, Detective Rink emailed or forwarded the email to the state attorney regarding the unlikelihood of secondary transfer. The state was fully aware of all this information and just continuously made conscious decisions to not disclose it to Mr. Jones. And as a result, Mr. Jones was never able to fully defend himself in this matter that he had a right to. He had a right to this information. The jury honestly had a right to hear the information, and they were not able to fully evaluate the case because the state continuously withheld evidence. And just a note about the shoe print. I would just like to point out that was a mass-produced shoe. That yes, there were some similarities with that, but the state could not say that that was an exact match. And I want to say that when law enforcement was running, or FDLE was running a test on the shoe, they went to a store to buy the same shoe. I want to say it was a Dillard's or something. They went into just a generic store to buy the same shoe. Had the jury had any of this information, they would have had more evidence for alternative suspects that they were never able to evaluate. If there are no further questions, we'd ask.
Can I ask a question? And I probably should know this, but could you remind me whether the record reflects that whether Mr. Jones is still under a death sentence in Tennessee?
He is. If there are no further questions, we'd ask you to remand for a new trial. Thank you.
Thank you very much. We're adjourned.
All rise.